District of Columbia, Office of the Tenant Advocate, tutorial video on post-public health emergency landlord eviction requirements. In the District of Columbia, a tenant may be evicted for one of 10 specific reasons, including non-payment of rent and lease violations. Landlord eviction requirements, non-payment of rent. Landlords may file an eviction suit for the non-payment of rent only if the landlord possesses a basic business license and a tenant owes $600 or more in back rent, and the landlord has sent the tenant a notice of past due rent that states, among other things, the total amount owed, that the tenant can remain in the unit until the account is current, and contact information for the OTA and the Landlord-Tenant Legal Assistance Network, and 30 days have passed since the landlord sent the tenant the notice of past due rent. All tenants being evicted for non-payment of rent in the District of Columbia must receive 1. A written notice of past due rent, 2. An opportunity to challenge the landlord's claims in court, and 3. An opportunity to bring the rental account completely current. Lease violations. After January 1st, 2022, a tenant can be evicted for any of the statutory reasons that were paused by the eviction moratorium. Lease violations post-public health emergency eviction protections. The court treats consistent late payment of rent as a lease violation. This means that the tenant loses the right to redeem the tenancy by paying all amounts owed. However, landlords are prohibited from evicting tenants for consistent late payment of rent that occurred during the public health emergency plus 60 days thereafter. Landlords must provide tenants they intend to evict with the following notices. For lease violations, landlords must send a notice to correct or vacate. For non-payment of rent, landlords must send a notice of past due rent. If you received a notice of past due rent or a notice to correct or vacate, you do not need to leave your rental unit. Once the notice period has expired for the notice of past due rent or the notice to correct or vacate, the landlord may sue for possession of the rental unit. Non-payment of rent. If the tenant brings the rental account completely current except for late fees, the eviction process ends here. Note, tenants cannot be evicted over unpaid late fees. A landlord may only file an eviction complaint in landlord and tenant court if 30 days have passed since the notice of past due rent and the tenant still has an outstanding balance that does not include late fees. Lease violation. If a tenant corrects the lease violation, the eviction process ends here. Note, tenants may want to notify the landlord that the alleged issue has been corrected. If the notice period has expired and the landlord does not believe that the tenant corrected the alleged lease violation, then the landlord may file an eviction complaint in landlord and tenant court. The landlord must also serve the tenant with the summons and complaint at least 30 days before the initial hearing date. Tenants may be served via personal service, where the summons is handed personally to the tenant, substitute service, where a copy of the summons may be left with a household member over the age of 16 present at the rental unit, and/or posting. If the process server has failed service attempts at least twice, the landlord may mail a copy of the summons and complaint and post a copy on the premises in a conspicuous place. However, this method requires time-stamped photographic evidence of a posted summons and complaint. Please continue to Part 2 of our eviction tutorial, From the Writ to Eviction Day. Or if you have questions or concerns regarding landlord requirements post-public health emergency, contact the District of Columbia Office of the Tenant Advocate at 202-719-6560.